everybody. I'm going to talk about my favorite subject, which is causation in medical malpractice cases. I'm going to talk about it from two perspectives. One is the lawyer's perspective on causation when the case walks through the door and what we need to do about causation to prove our client's case. And the second is the legal test for causation as well. I see these as two separate issues. Brenda, next slide, please. So one of my missions in the last couple of years is to get people to think about causation in tort in a different way. It's my view that the case law on causation, both in the Court of Appeal and in the Supreme Court of Canada, has added to a lot of confusion about causation in tort. And I'm going to talk about the leading case on causation from the Supreme Court of Canada and why it really has not done much of a service to the legal profession. So I'm going to re-examine what the legal test for factual causation is in tort law. And then I'm also going to suggest new ways that we ask causal questions, which I think is very important, particularly for those of you who do jury cases. I think you need to rethink how you ask the causal question. And let me just get into it right now. Next slide, please. So the starting place, I think, has to be where causation fits in. And the first question is a duty of care question. Did the defendant owe duty of care? That's a legal question for a trial judge. In most of our cases, there really isn't an issue about duty of care. The next question is, was there a breach of the duty of care? And that's a matter for the trier of fact, a jury, or in a non-jury case, the judge. And at that point, after we have found a breach of the duty of care, we then get into the causation question. And I interchangeably use causation and cause and fact to describe this step. It's a question for the trier of fact, and it is a factual as opposed to a legal determination, which is important, and I'll talk about that in a few minutes. It's important to understand that causation must turn on the evidence, but triers of fact, whether judges or juries, are permitted to make a determination on causation based on inference. In fact, arguably, inference is the most important way that triers of fact draw conclusions about causation. And then the case law is also clear that the trier of fact is entitled to bring an appropriate amount of common sense to the determination of causation, provided that common sense is operating on the evidence that has been called in the case. After causation is determined, then the subject of legal causation comes up. And legal causation is an unfortunate term for the next step because it isn't really causation in the way we think about causation. And this has to do with proximity and foreseeability, which I'm not going to get into, but I'm going to talk about legal causation in another sense later in my talk. And then damages, and finally contributory negligence or contributory fault under the Negligence Act. I think it's extremely important to point out that contributory negligence has nothing to do with causation. And there are times when the courts have confused the two concepts, and they shouldn't. Next slide. So I said I'd talk about causation in two different respects. The first I call the practical challenges to proving causation. And here, what we want to do is prove causation based on something more than our burden of proof. Remember that the plaintiff has the burden of proof. That burden is more likely than not or greater than 50%. But in medical malpractice cases, we want a much stronger case on causation than just 51%. We want to eliminate all possible causes other than the cause that supports our claim. If we can't do that, then we don't pursue the claim if you can't do it. So we need to, when the file walks in the door, we as lawyers and advocates need to think about causation early, before we talk about damages, sometimes even before we talk about standard of care. we need to address causation, because if you can't win on causation, don't pursue the case. And that requires you to develop a theory of causation. For those of you who've heard me talk before, I talk about the importance of getting all the relevant records. I talk about the importance of a careful review of those records, the research that's necessary on a type of medical research to identify the medical issues that might or might not support your causation argument. And then once you've formulated some sort of an approach to causation, it's at that time that you engage experts to see whether that approach is a good one. Some people would do it the opposite way and allow the experts to develop a theory of causation. I find that doesn't work. That no expert is going to give your case the attention that you should be giving your case. So I think that's very important. And in the end, causation turns in many of our cases on what we call the differential diagnosis. What we do is we list all of the possible things that might explain the harm that occurred to our client, and then we determine which is most likely. Which you look at the things that support that theory of causation, and you look at those things that run counter to your theory. The second aspect of this is what I call the legal test of causation. And legally, when you're in the courtroom, you need to prove that there is a link between the wrongful conduct of a wrongdoer, a tortfeasor, a defendant, and the harm that was caused to the plaintiff. We run into a lot of problems with the legal test for causation, particularly in medical malpractice cases where we're dealing with multiple causes. I have as an example here delayed diagnosis cases. So delayed diagnosis cases where there may be multiple medical actors that contributed to a delay in either diagnosing or treating the patient's condition. You need all of those negligent actors to have contributed to the harm in order to establish your causation case. But it's how we ask the causal question that creates no end of difficulty for courts and for judges. And then even with the legal test for causation, you need your experts to ensure that you're going to meet that legal test. Next slide, please. So what is the legal test for causation? And the test for causation is the but-for test. Okay. Every lawyer knows about the but-for test. But in a series of cases, starting in 1996, with a case called Affey and Leonati in the Supreme Court of Canada, there emerged what I'll call a new test of causation, but not a factual causation. A new test of causation that is not factual causation. It was called the material contribution test. And in Affey, what Justice Major said was that there are times when the but-for test will fail us. And where the but-for test fails us, the law ought to permit an alternative test called the material contribution test. That test was not applied in Affey. And as I'll point out, the test has actually never been applied in any case in the Supreme Court of Canada ever. And in any case where a lower court has invoked the material contribution test, where that case has found its way to the Supreme Court of Canada, the Supreme Court of Canada has reversed it. So I'm going to suggest to you that there is no alternative test for factual causation to the but-for test. But-for test is the only test that exists at law for the purposes of determining factual causation. Now, many of you will know the leading Supreme Court of Canada case on this point, which is a case called Clements and Clements, a decision of Chief Justice McLaughlin, as she then was. It's the leading case. It's been cited by all of the subsequent cases as the authority for the proposition that but-for is the default test, but there is an alternative test for causation, and I will suggest to you that Clements is a severely flawed decision of the Supreme Court of Canada. It has led to more confusion about causation than prior cases, and many errors by courts at both the trial level and the appellate level in all provinces. So what's the problem? The problem is, first of all, that in Clements was a motor vehicle case, and but-for was easily applied to Clements. There was no reason to get into this notion of material contribution. But let me back up a little bit historically as well, just to talk about this. I said that ATHI in the Supreme Court of Canada was sort of the first step in the development of an alternative test to but-for, the material contribution test. That test was later considered in another Supreme Court of Canada case called Hankey and Resurface, another case where there was absolutely no reason to contemplate an alternative to but-for, because but-for was very, very easily applied in Hankey to the very, very simple facts of that case. So there was no reason for it. Unfortunately, though, the Alberta Court of Appeal in Hankey decided to go down this material contribution road, and it needed to be corrected by the Supreme Court of Canada. So the Supreme Court of Canada revisited material contribution in Hankey, and again, it was Justice McLaughlin in that case, Chief Justice McLaughlin. And the material contribution test was tweaked in Resurface. It took a bit of a change, but that wasn't the end of it. When this matter got back to the Supreme Court of Canada in 2012, Justice McLaughlin thought further changes were made, and it was no longer called the material contribution test, but rather the material contribution to risk test. And in Clements, Justice McLaughlin, Chief Justice McLaughlin, qualified, limited, or narrowed the previous versions of the material contribution test to provide that it only applies where the plaintiff has proven that one or more defendants, one or more tortfeasors, named defendants, are responsible for the loss. In other words, but-for had to be proved against the group of defendants. That is new. So it isn't that but-for doesn't apply, but but-for applies what I'll call globally. That's a dangerous word to use given what the entire Court of Appeal later said in Sachs, but in Clements, Justice McLaughlin clearly used the phrase global contribution. So the first step in that case was, under the new material contribution to risk test, was that the plaintiff must establish but-for against a group of defendants, but it must be impossible for the plaintiff to establish which defendants amongst the group is responsible for the loss. Well, that's not an alternative to but-for, because but-for has already been proven against a group of tortfeasors. And one important message that demonstrates why Clements is so flawed is that that description of the test precludes innocent causes from being considered. So harm might result from wrongful conduct or from wrongful conduct combined with innocent conduct. And a test for causation must be able to determine the role of both wrongful conduct and innocent conduct in bringing about harm. The test in Clements does not. The other point to make about the test in Clements is that if the plaintiff has to prove but-for as against a group of wrongdoers, people named as defendants in the action, why do we need an alternative test at all? But-for has already been proven as against the group. A more elegant solution to the problem described in Clements would have been a secondary shifting of the burden of proof and say to the defendants, well, we've now proven that you as a group have caused the harm to the plaintiff. Fight amongst yourselves in terms of liability. The plaintiff has done all the plaintiff can do. The threshold that the court describes in Clements for invoking this alternative test is a very high threshold, impossibility of proof. Because of the fact that the plaintiff has to prove but for is against the tortfeasors globally, my position is that the test is not an alternative to but for at all. A couple of other observations to be made about the test that's described in Clements. Number one is that causation, or cause and fact, is a factual inquiry, which is true. It's a factual inquiry. Whereas the alternative test that's described by the court, the material contribution to risk test, has been described as legal causation. You'll remember that I spoke a few moments ago about legal causation being things like proximity and foreseeability. Now, legal causation before Clements, legal causation was a notion that operated to limit liability. So even if you could prove a causal connection between wrongful conduct and harm, if you can't demonstrate proximity or you can't demonstrate foreseeability, legal causation would operate to deprive the plaintiff of the remedy. In other words, causation is established, but you still can't get your remedy. So legal causation, to my mind, is something that is liability limiting. The legal causation of Clements, however, is liability expanding. So if the material contribution to risk test is a test of legal causation, and legal causation is usually based on policy grounds, having nothing to do with a principled notion of connecting or linking wrongful conduct to harm. If it's a legal causation, a policy decision, then it's one that is used to expand liability. That is, find liability where the but-for test otherwise would not. And that is not how legal causation operates. I think it's a mistake to call it legal causation. A number of cases have done that, but I think it's a mistake to call it legal causation. I mean, there may be reasons to have an alternative to but-for, but this is not the reason for an alternative to but-for. So it's a liability expanding concept, this notion of legal causation. The other way that this has been justified is on a notion of corrective justice. So what's corrective justice? The Supreme Court of Canada talks about corrective justice in Clements. And corrective justice is simply how the tort system operates as a general matter of principle. That is, it's the idea that as between a wrongdoer and a victim, the burden of loss ought to be shifted from the victim to the wrongdoer, where the wrongdoer's conduct is tortious. I mean, it's that simple. That's corrective justice. The idea that corrective justice would operate where but-for fails is a much more difficult concept, because what is the basis for shifting the burden of loss to a wrongdoer whose act or omission has not been shown to be connected to the harm? It hasn't been proven, and it may not have caused the harm. And for the answers to that, I think is beyond the scope of my talk today. The answers to that question, you need to go back to some jurisprudence from the House of Lords in the UK, back to a series of cases that I think explain this much better than the Canadian cases do. And I have a paper that'll be published soon about this issue, but the cases are McGee, Fairchild, and those kinds of cases. You have to go back to those cases. So I don't want to get too caught up in the idea of corrective justice, but my position is neither corrective justice nor legal causation, as it's described in Clements, is a justification for a departure from but for. But more important than all of that, I think for the purposes of all of us who litigate these cases, is that but for is equal to the task in virtually every case that we will ever see as litigators. Virtually every case. We never have to resort to but for in any case that walks, or to an alternative to but for, in any case that walks through our door, because but for is equal to the task. But it depends how you ask the question, and that's my problem. You must ask the question as a but for question. So let's go to the next slide, Brenda. So how do you ask the question? And remember, what I'm dealing with is not the simple case here. It's not car rear ends another car. The causation question is, had you put your brakes on, which avoided the collision? That's easy. It's these multiple causal cases that we often see in medical malpractice litigation, like the Saxon-Ross case, which is a Court of Appeal decision involving potential delayed diagnosis of a very serious problem. And one of the problems that we have, of course, with but for is that but for, when you ask the causal question, you must ask the causal question of an individual defendant. You can't ask the question of defendants at large or people at large. So that tort law demands that where you find defendant A to have committed a breach of his or her duty, you must then ask of defendant A whether that breach of duty is related to the harm. And that way it's individualized or individuated as against that person. But you can imagine a delayed diagnosis case where there are multiple players involved. You can imagine that by asking that question of any single defendant, you may not find causation where you know it to exist. The classic example is the old case of Cook and Lewis, the two shooters. They're out hunting, and they think they see some game in the woods, and both Hunter A and Hunter B shoot their rifles towards the game, and it turns out that they struck Mr. Lewis, but only one of them struck Mr. Lewis. They just don't know which one. So if we ask the but for question, but for the negligence of Hunter A, would Mr. Lewis's harm have been avoided? The answer is we can't prove that. We don't know, because we don't know which hunter shot Mr. Lewis, and therefore we haven't proved causation against Hunter A. Then if we ask the question of Hunter B, we get the same negative answer, and therefore we find no causation. So we fail to find causation where we know causation exists. Well, that's unacceptable if the but-for test is the legal test for cause and fact. That is not acceptable. And I say the mistake we're making is how we ask the question. Although the two Hunter case is a difficult case. But I'm going to give you an example of how you might ask questions in multiple defendant cases. So the problem again in medical malpractice, not unique to medical malpractice, but what we see is that the negligence of A may need to combine with the negligence of B to cause the harm. And so if I were to confine my but-for question to A only, I would get a negative answer because A's breach of duty on its own may be insufficient to cause the plaintiff's loss. It may need to combine with B's breach of duty in order to cause the loss. So somehow we have to tease in the involvement of wrongdoer B when we ask the causal question of wrongdoer A. Okay, and then we want to do it in simple language. So let's go to the next slide. So I'm going to give you an example here. Either defendant A or defendant B were sufficient on their own to cause harm X. So let me give you the classic example used in some of the academic writing on this subject. The classic example is that there are two negligently set fires, and those two fires merge before destroying the plaintiff's property. Each fire on its own was sufficient to cause the loss. That is, had fire A happened without fire B, the loss would have occurred. Had fire B happened without fire A, the loss would have occurred. But both A and B merged together before the loss to cause the loss, each being sufficient. Sometimes we get into a problem of this notion of necessity. Do we have to prove that fire A was necessary to cause the loss? And those of you who have looked at the law will see that in Clements, Chief Justice McLaughlin introduces the notion of necessity and says that necessity is part of the causal question. In some circumstances it is, but it can't always be. And this is an example of where it can't always be. So I think that Clements did us a disservice by not qualifying the involvement of necessity. So these cases are called overdetermination cases. In other words, there's more than enough power in any one of these two fires to cause the loss. There's more destructive power than you needed to cause the loss. So if we ask the causal, the but-for question, but for the negligence of fire A, would the loss have been avoided? The answer is no. B still would have happened. Therefore, we haven't proven causation against A. If we ask the same question of fire B, we get the same answer. No, it's not causative because the loss would have occurred as a result of fire A. Therefore, we get into this paradoxical situation where neither A nor fire B caused the loss. Well, that's absurd. Now, if but for is the test, and that's how we apply but for, then but for can't be the test of causation, because we can't have a test of causation that fails to find causation where we know it to exist. We must have a test that will find causation where we know it to exist, and that doesn't. So either but for doesn't work because it's been interpreted as described in some of the academic writings as only a test of strong necessity. And when we think about strong necessity, again, we get back to what Chief Justice McLaughlin said in Clements, referring to the requirement that the wrongful act be necessary to bring about the loss. Well, that can't be so. That can't be so. It sometimes is so in the simple case, but it isn't so in the delayed diagnosis case. It must not be. My proposition is that we have not asked the causal question, the but-for question, properly. Part of the reason is because but-for, we explain the test for causation as but-for, and when you look at the case law, but-for is always in quotes. What does that mean, that but-for is always in quotes? It means it requires explanation. So but-for is, as I say on the slide, it's the label for the test. It is not the definition for the test. And therefore, our causal questions should never include the words but for, especially to a jury, because it's meaningless without more. That's why it's in quotes, because we all acknowledge, all the courts acknowledge, that but for is meaningless without further elaboration so that the jury can understand it. It can't be just a case of a question of strong necessity. And I go back a little bit. I like to think of causation. I like to think of rules of evidence. I like to think of all of these things in terms of the foundational principles upon which these things are based. And the but-for foundation, the provenance of the but-for test, is something known as the counterfactual. So again, we don't want to use the term counterfactual when we're talking to judges and juries, but I think we need to have a discussion about the counterfactual so that we can understand where the but-for test comes from. And by understanding where the but-for test comes from, we can then address our minds to the proper question to ask when it comes to causation. And that's, so let's talk briefly about the counterfactual. Well, the counterfactual is a process that judges and juries need to go through, where they imagine a world that does not exist. It runs counter to the facts. So you imagine, let's take the simple case with the car, the guy doesn't apply the brakes and the car hits the car in front. You are to imagine a world where the wrongdoer applies his brakes. And you were to ask your question, in that imaginary world where the wrongdoer applied his brakes, would the collision have been avoided? Well, the collision wasn't avoided, that's imaginary too. The real outcome is it happened. So we imagine as jurors or as triers of fact, we imagine this counterfactual world where we take out the wrongful conduct and ask what would have happened. Both hypothetical questions, both hypothetical, both didn't occur, both run contrary to the facts. But that's what juries do. And so that's the basis of the but-for question. The but-for question says, if we remove the wrongful conduct, how would the outcome have been different? But sometimes in these more complicated cases, we must remove more than just the wrongful conduct of an identified tortfeasor. We may have to remove the wrongful conduct of 2 or 3 or more identified tortfeasors. And I argue that in some cases, not only must we remove hypothetically the act of some tortfeasors, but we may have to tease out some innocent factors as well. So again, I said I wasn't going to get into the UK cases, but the case that really starts all this off is a case called McGee and National Coal Board. And that is a case involving an innocent cause and a guilty cause and inference. And really what I say is the ultimate application of the but-for and the proper formulation of a but-for test, even though some courts have wrongly interpreted McGee as proposing an alternative to but-for, but I think those courts are wrong. So we need to think about but-for from the ground up, from its foundation in the counterfactual, in order to properly frame a question, because in the end, the causal question must tease out the role that the wrongful conduct had in bringing about the harm. And you cannot always tease out the role of the wrongful conduct without looking at the context in which the wrongful conduct occurred. It may be a series of events, each dependent on the other, that caused the harm. And if the causal question is confined only to a single defendant and a single act without considering how phenomena really occur, multiple causes, then that's problematic. And that's really was the point originally in Athy and Leonati when we first created this material contribution test of causation, which actually doesn't exist. But when Justice Major was talking about material contribution, he specifically talked about the fact that phenomena are often the result of, almost always the result of multiple events, some of which are innocent and some of which are guilty. That's a fact. And again, that's a glaring omission from Clements and Clements, the failure to devise a test that recognizes that multiple events, both innocent and guilty, might contribute to an outcome. And just because an innocent event contributes to the outcome doesn't let the guilty player off the hook. Okay, so we must find causation where it's known to exist, and but-for as a test of strong necessity may fail to do that. That was the criticism that Major had, but it led to a lot of bad decisions to follow, including Hanky and Resurface and Clements and Clements. Next slide, please, Brenda. So one of the things I'd like to see, and if you look at the case law, I'd like to see that we stop using words that mean nothing to lay people like jurors, even in the analysis that we as lawyers take to causation. And I'd like to see us not use the phrase but for in causal questions. If you look at the case law, you'll see there's been a ton of debate about whether the causal question should be phrased as a cause rather than the cause. And that's a very important thing. You'll see a serious conflict in the Court of Appeal on that very issue in a case called Suriejo, or I can't pronounce it, in 2017, which found one thing, and then in that same year, Sachs and Ross found something else. The cases under the same court are completely irreconcilable. And then, should we have the language caused or contributed, or does that offend Clements and Clements? Now, the problem is the development of a material contribution alternative to but for has given the word contributed a bad name. That's problematic too. Contributed, I argue, is not part of an alternative test, but is part and parcel of a properly formulated but for test. So I put a question here: has the plaintiff proven on a balance of probabilities that to prevent harm X, the breach of duty of defendant A would need to be absent? Here I have not used but for language. I have not used a cause or the cause. I've avoided cause or contributed. It's a much simpler question, I suggest to you, than the questions that we see in some of the case law. Next slide, please, Brenda. So here's another example. Neither A nor B were individually sufficient to cause harm X, but both A and B were necessary for harm X to occur. So this is the classic delayed diagnosis, delayed treatment case, where there are nurses and doctors and other people involved in errors like Sachs and Ross. And A and B, each of these two acts, or there may be A, B, C, and D, like there are 5, I think, in Sachs, they're interdependent. They rely one on the other. Therefore, on their own, no single act is necessary. On their own, no single act is sufficient, but they must combine to be both sufficient and necessary. And again, if we were to ask the traditional but-for question as a question of strong necessity in this scenario, we would always find no liability. That can't be so. So 2 possible questions: has the plaintiff proven on a balance of probability that the breach of duty of defendant A caused or contributed to the harm? That can't be the question, because we would get the wrong answer. Question 2, has the plaintiff proven on a balance of probability that harm X occurred due to the breach of duty of defendant A on its own or combined with event B? The second question recognizes how phenomena really occur. And when I say event B could be another tortious cause or could be an innocent cause. Again, a shortcoming of Sachs and Ross. Next slide, please. Okay, so I wanted to spend a little bit of time, if I can, on not the legal test, but what we do, come back to what we do as lawyers in terms of proving causation and the important role that science and medical literature play in the causation analysis. And I did want to leave some time for questions at the end, so I'll try to do that. Some people debate whether they want their experts to include literature in their reports. I think the inclusion of literature is a very good idea. I think it reinforces and bolsters an expert's report, but you as an advocate for the lawyers on this call, you must ensure that any literature that is included in the expert report, you have read it, and you must ensure that there's nothing in that literature that contradicts your theory of liability, or if there is, that the inconsistency can be explained by your expert in a way that does not undermine your theory of causation. Very, very important. So I think it's a good idea to have literature. I try to have literature in my expert reports as much as I can. A caution about epidemiology and evidence-based medicine. Those of you who practice in the motor vehicle field, and I don't, but I used to long ago, know that there's a lot of focus on evidence-based medicine, that no-fault benefits are essentially crafted to reflect what is called evidence-based medicine. In my view, it's an abuse of evidence-based medicine. Evidence-based medicine and epidemiology were not meant for these purposes. So I think the important thing about epidemiology and evidence-based medicine is for you to recognize that often it doesn't apply to the individual. Evidence-based medicine was never applied. There's no formula for the treatment of whiplash that works in every patient. So evidence-based medicine was not intended for the individual. Epidemiology often involves very, very large cohorts of patients, different ages and different medical histories and different everything. So that if an expert comes up with a statistic about the probability of avoiding harm in the case, that statistic may have no application to your case because the cohort on average may differ so dramatically from the circumstances that you face with your client that it has no application. So a word of caution about epidemiology is that we have to be sensitive to the fact that it may not and probably does not apply in most scenarios to our cases. So be cautious about epidemiology, and you'll probably see it more on the defense side than you will on the plaintiff's side. And then there's medical literature that might be contrary to your theory of causation. I suggest you know that before you get into your case, before you deliver your expert reports, before you get to examinations for discovery. I think you need to squarely face into any medical literature that is contrary to your theory of causation. And if it's contrary to your theory of causation and you cannot reasonably explain it away, then you must reconsider whether or not your case has merit. And one thing about medical malpractice cases is they're hugely expensive. They're extremely complex. They're always defended by very good lawyers on the other side of the case. Both HIROC and the CMPA appoint very skilled lawyers, experienced lawyers on the other side of the case. And they're not going to leave any stone unturned, and nor should you. So if your theory of causation is going to be undermined by medical literature, you need to know that up front so that you don't invest in a case that may not have merit. We don't want to pursue cases that don't have merit. It's bad for everybody. It's bad for the defense. It's bad for the plaintiff. It's bad for the lawyer. Let's make sure early on in our cases, long before we get to examinations for discovery, that our case has merit. And let's only pursue meritorious cases. And the other thing I want to talk about, and really a pet peeve of mine, is junk science or flawed medical literature. My practice is primarily obstetric malpractice litigation, primarily birth trauma. And so I've used two examples of what I consider to be enormously flawed literature. There's a lot out there. So I mentioned here that your experts need to be aware of the flawed literature. One example is a publication by the American College of Obstetricians and Gynecologists in 2003. And another is a publication by the Society of Obstetricians and Gynecologists of Canada in 2020. Both the ACOG and the SOGC are very reputable organizations that are highly respected and would be respected by a trial judge. Both these publications are hopelessly flawed in very significant ways. And both of these publications contain things that would undermine significantly the defense or the prosecution of a birth trauma case. If you, as the advocate, are not aware of these things, and I only use this as an example, it isn't confined to obstetrics, but if you, as the advocate, are not aware of errors, flaws, or pure junk science, then you run the risk of pursuing a case that might not pursuing a case that might not have merit. Now, you're going to say, well, I rely on my experts to know this sort of stuff. You can't. You just can't. I can't tell you how many experts in the fields of obstetrics and neonatology I've run across since 2003 who thought the ACOG 2003 publication was authoritative. It's not. And I know of one expert who was cross-examined at trial not long ago on ACOG 2003 on causation, critical things on causation of birth trauma case. And the expert differed in opinion from ACOG, but was not really able to explain why he took a position different than ACOG. I've been through the document with a fine-tooth comb, and I would be able to brief my expert on why ACOG cannot be followed. And incidentally, ACOG resiled from much of their 2003 publication in its second publication in 2014. Again, many experts don't know that. They're learning, but they don't. You need to know that as an advocate for these people. You really need to know that. So, to my mind, good advocacy in medical malpractice cases involves a lot of scientific research on the part of the lawyer, a lot of understanding the issues, a lot of meshing those issues with your facts, which can also be difficult because we have cases where there are 2,000, 3,000, 10,000 pages of medical records that we have to reconcile with our theory. And that's a very time-consuming, difficult thing to do. And again, it's been my experience that if there are 5,000 pages of records, I can't really rely on my experts to go through those with a fine-tooth comb. I find I need to do it, or they don't organize it properly. In most cases, some will and some won't, but in most cases they don't. And that is highly problematic for us because, again, if our case has merit, we want to know it, we want to pursue it, no matter what the expert has to say. If I get an opinion from an expert on liability that is good for my case, I still cross-examine the expert to determine how good it is. And I've done enough research that I can challenge that expert on that report to make sure that there's good reason for me and my client to rely on what the expert says. If an expert gives me a report that's bad for my case, I do the same thing. I say, why do you think it's bad for my case? Have you considered this publication, that publication, this fact, this theory? This is what we need to do as advocates in these very complicated medical malpractice cases. And there's no substitute for hard work. That's how we're going to do it. So next slide. So here are my three essential arguments on causation. The first one is there is only one test for factual causation. It's the but-for test. There is no other test. There is no such thing as material contribution when it comes to factual causation. It doesn't exist. And for all practical purposes, each and every one of us should simply assume that the counterfactual but-for test is the only test that we need to look at. The material contribution to risk test, as that's defined in Clements, is not a test for factual causation. It's problematic as a test of legal causation. It's problematic if it's based on corrective justice, but that may be a discussion for another day. I think that we can overcome these things by overcoming what some people call impossibility of proof. Impossibility of proof can be overcome in many cases by the appropriate use of inference and material contribution as an element of but-for, as opposed to a distinct or a different test. We also need to look at the older case of Snell and Farrell, 1990 case of Snell and Farrell of the Supreme Court of Canada, which cautions that we use a robust and pragmatic approach to causation, that scientific proof is not necessary, that inferences can be made, and all you need is enough evidence where a trier of fact can infer a causation outcome that favors your case over the defense. I do argue that, while we must acknowledge that the burden of proof is always on the plaintiff, it may be that that burden of proof is not immutable, as Justice Sapinka suggests in Snell and Farrell, and there could be some notion of a secondary burden of proof or some sort of shifting of the burden of proof to the defense. The courts have been careful not to call it that, and what they essentially say is that once the plaintiff has established a prima facie case of causation, in the absence of an explanation from the defense that essentially trumps the plaintiff's theory, the plaintiff will succeed. And then a properly formulated but-for test is based on the counterfactual. It must contemplate a cause rather than the cause, but not use those words. You must make a distinction between the burden of proof, which is a balance of probabilities are greater than 50%, and the threshold of proof of causation, which is not the same. So the burden of proof is 50%. The threshold of proof is something more than negligible. In other words, the straw, it could be the straw that breaks the camel's back, and you could meet the threshold of proof of causation. These are two very distinct concepts that we must all understand. The difference between the burden of proof, greater than 50%, and the threshold of proof, something more than de minimis. And de minimis is defined as something more than negligible. So if there are enough facts, if there are all kinds of causes, but enough facts that would allow a judge or a jury to conclude that the wrongful act was a contributor to bringing about the harm, that is sufficient. So I think I've used up most of my time, and I haven't left a lot of time for questions. I don't know if there are any questions. I don't see any.
I don't see any either right now, Richard. So you're good.
Okay. Well, that's my talk. If you feel like you want to send me questions along by email, please feel free to do so. And thanks for attending.
Thanks, everyone. Thanks for attending. Thanks so much, Richard.
You're welcome.
Okay, take care. Bye.